All right, good morning, everybody. Let's go ahead and call this committee meeting to order.
Representative Brady,
Here.
Representative Bratton,
Here.
Representative Chestek,
Here.
Representative Filer,
Here.
Representative Kelly,
Here.
Representative Lean,
Here.
Representative Singh,
Here.
Representative Webb,
Here.
Chairman Washut.
Here.
Excellent. Well, as a few housekeeping items, just before we begin, let's just make sure that all comments go through the chair for decorum, that we keep things civil for everyone. And yeah, that's all I got. So the first bill for our consideration today will be House Bill 207, the Religious Freedom Restoration Act. And our good chairman is the lead sponsor of that. So Representative Washut, go ahead.
Thank you, Mr. Chairman, committee. It's a little unusual sitting on this side of the table this morning, but I welcome the opportunity. Still fighting that terrible cold I had last week, so I brought some heavy hitters with me to help field some of the questions today. We, the people of the state of Wyoming, grateful to God for our civil, political, and religious liberties, and desiring to secure them to ourselves and to perpetuate them to our posterity, do ordain and establish this Constitution, the preamble to the Wyoming State Constitution. Together with Article 1, Section 18 of the Constitution that says, the free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be guaranteed in this state. That's why we're here today, and that's what this bill pertains to. The Wyoming Religious Freedom Restoration Act. Let me tell you a little about the history that brings us to where we are today. When I was a small boy back in 1963, the United States Supreme Court, yes, I am that old, the United States Supreme Court in 1963, in the case of Sherbert versus Werner, ruled that the strict scrutiny standard would be applied when evaluating whether or not a statute infringed upon the free exercise clause of the First Amendment. By strict scrutiny, the court meant that whenever a government act burdens a person's right to freely express and exercise his religion, that burden must be necessary to achieve a compelling government interest, and if such a compelling government interest exists, that the burden must be narrowly tailored to utilize the least burdensome means available to achieve that compelling interest. That ruling was the law of the land for decades. It worked well, and everyone grew accustomed to it. Then in 1990, in the case of Employment Division versus Smith, the U.S. Supreme Court abandoned the strict scrutiny standard in cases where government actions were not targeted, but were instead of general applicability, and just incidentally happened to infringe on a person's religious practice pursuant to the free exercise clause of the First Amendment. This abandonment garnered an almost immediate rebuke from the American public and from Congress. In 1993, a nearly unanimous United States Congress passed the Religious Freedom Restoration Act. It was signed into law by our 42nd president, the former governor of Arkansas. And just think about when was the last time U.S. Congress came together in such strong bipartisan support for anything of consequence. Then in 1997, in City of Bourne versus Flores, the U.S. Supreme Court ruled that federal RFRA law passed in the United States Congress only applied to the federal government in federal cases and did not apply to states. 10 years ago, the man sitting to my right, former Representative Nathan Winter, presented a Wyoming version of the RFRA law for the first time in this body. It sailed through the House. It came up just a little short in the Senate. In 2023 and again in 2024, I brought the bill, but neither time did the bill make it through the tight time frame and the gauntlet of the citizen legislature that we work in. Now I have before you the 2025 version. I'll walk you quickly through the bill if it pleases the chair.
Any questions from the committee? Go ahead.
All right. I call your attention to the co-sponsors. I'm honored by the number of and the quality of co-sponsors, both in the House and the Senate, who have joined me in bringing this bill. On the bottom of page 1, we go to 139, 124, which is the Wyoming Governmental Claims Act. Continuing on the top of page 2, lines 1 and 2, we see that under this act, a government entity is liable for damages resulting from a violation of these new statutes that we're creating in this bill. Page 2, lines 10 through 14, talks about 925-101, which is again, a new statute. Page 2, lines 16 through 23, we begin with the definitions. We define the term burden. This language is commonly used in RFRA laws and is also found in some case law pertaining to the First Amendment. On page 3, lines 2 through 11, carrying on from page 2, we have specific acts that fit this definition of burden. On page 3, line 13 through 16, defines the compelling governmental interest, what it is. And again, this is fairly standard language found in other RFRA bills, as well as in case law. On page 3, lines 18 through 22, we define the ways one might exercise his religion. Again, this is fairly standard language. Page 4, lines 1 through 3, defines a person. Page 4, lines 5 through 11, defines the limitations on state action. I'd just like to read that section. State action means the implementation or application of any law, including but not limited to state and local laws, ordinances, rules, regulations, and policies, whether statutory or otherwise, or action by the state or a political subdivision, local government, municipality, instrumentality, or public official authorized by law in the state of Wyoming. So those are the things, that's the state action that we're talking about in this bill. On page 5, lines 14 through 22 pertains to the new statute 925-104 and addresses a claim or defense under the act. So a person who is burdened or likely to be burdened may assert a judicial or administrative proceeding and may obtain relief. And the relief includes, but is not limited to, and continuing over on page 6, injunctive relief, declaratory relief, compensatory damages, costs, and attorney's fees. And then the bill is effective July 1, 2025. And with that, I'll stand for questions on some of the legal questions. I might call a friend to my left or also receive some testimony from former Representative Nathan Winter. But committee, I'm open to questions.
Any questions from the committee? Representative Chestick.
Thank you, Mr. Chairman. I do have a lot of questions, as you might have guessed. And I'll try and be brief, but some of these will take a little bit of time. My first question is on page 4. You just read the line. State action means the implementation or application of any law, including but not limited to state and local laws. So any law and not limited to state suggests pretty clearly to me that federal laws are also covered. So if a person, and we'll get to the word person in a second, if a person tries to comply with federal law at the risk of some administrative federal action saying you must do this thing, and that thing that the federal law compels that person to do would violate this act, aren't we putting that person in a catch-22 where they have to either abide by the federal law or abide by the state law that are completely inconsistent with each other?
Representative
Mr. Chairman, Representative Chestick, I'll begin and then perhaps Mr. Chofin would want to chime in as well. But there is very similar legislation in place at the federal level. All right, we have a federal RFRA law that is in existence and is applicable to federal actions. So this will be a complementary type of legislation. So I don't see where we would be in conflict in federal law and in state law with a similar bills in both domains. Mr. Chofin?
Thank you, Mr. Chair. Representative Chestek, that was the correct answer. There's a federal RFRA, which has been in place for 35 years, and it's worked in practice. And this, obviously, it's state action, and so the definition of state action being any law, and that including means obviously what's listed here, but any other kinds of law that might be considered state action is included. But as was just said, the federal RFRA has been in place for a very long time, so there would not be any conflict.
Sir, please state your name for the record.
Sorry, my name is Greg Chafuen, Chafuen.
Thank you, Mr. Chaffin. Representative Chestek.
Does the federal RFRA law have the same definition of state action?
Mr. Chaffin.
Representative Singh, Representative Chestek. So the federal RFRA didn't have as robust definitions. Congress, as soon as this decision was passed down in 1991, 1990, they quickly acted to pass this RFRA. And so the intent was fairly understood, what it meant. Over the years, in those 35 years, many court cases considering RFRA, upholding its constitutionality, putting it into practice, have clarified what various of these definitions mean. And so what this RFRA has, just like 28 other states, this uses definitions that are common throughout the states when they apply what is compelling interest, what is burden, what is person, et cetera.
Any follow-up? Representative Chestek.
Yes, I have other questions on other topics. Also on page 4, the definition of person includes corporation, and then on line 18, a person's right to the exercise of religion. Can a corporation have religious beliefs? I mean, a corporation lives forever. It doesn't have to worry about the afterlife. So how does a corporation can a corporation have religious beliefs that can be protected by law?
Representative Singh, Representative Chestek. So this was a question that went to the Supreme Court with the federal RFRA. They included person, and when they were reviewing that statute, they said, look, the Congress didn't say otherwise than what the Dictionary Act uses, and person in the Dictionary Act includes as corporations. And the reason that works is because if you're a private person thinking a mom and pop shop, if you're selling something individually, or then if you start to incorporate and you're small mom and pop shop still, you don't lose your religious freedom rights just because you've started an incorporation and now you might be forced to do something by the state that would make you violate your conscience rights. So in that way, when the Supreme Court reviewed that question, they said, yes, if you're a closely held corporation, you can't exercise your rights because of that personal connection to the corporation. Now, it is left open if a corporation is so large that you can't determine any religious belief or religious burden that might be imposed, then a corporation wouldn't be able to even get out of the starting gate because they wouldn't be able to show a substantial burden on a religious practice because they wouldn't be able to show a religious practice to begin with.
Representative Chestek.
Following up on that, we have the Hobby Lobby case, which was a closely held corporation, but look at the size of Hobby Lobby. It's a very large corporation. It has stores all over the country and billions of dollars of revenue. It's a very large corporation. And that's the case that says that closely held corporations may have religious beliefs. It's a very short hop from there, isn't it, to say, well, if a company as large as Hobby Lobby can have a religious belief, why can't a publicly traded company? I think we're starting there's a very slippery slope here. Any comments?
Mr. Chaffin.
Representative Singh, Chairman Singh, Representative Chestek, you know, some people have said that back then when that case was decided almost 10 years ago, and there have been studies showing that that is not the case. There has not been a slippery slope. There's not been a large number of cases filed like this. All of these studies, academic studies and law review journals, show that RFRAs work as intended. They protect people of minority faiths and people of majority faiths that have minority views. It's not abused. There's still a process that has to go through. And what these experts in the field, professors at law school, Professor Doug Laycock at UVA, say that, you know, this balancing test is actually what's great for religious freedom and states that want to pass anti-discrimination laws of whatever sort, because this is a fair balancing test. If you didn't have this kind of fair balancing test, You may not have those other kinds of anti-discrimination protections to begin with, because it would be an all or nothing battle of pass this, undermine religious freedom, and you just not have that at all. But having this balancing test, you can have both and good religious freedom laws and states' interests passing all sorts of other anti-discrimination laws.
Representative Chestek.
Thank you, Mr. Chairman. Another issue, on page 3, definition of exercise of religion means the practice or observance of religion. Now, the Supreme Court has distinguished between the right to believe and the right to act. There's differences. The right to believe is pretty much absolute. The right to act is not, because acts affect other people. When you include the word practice, that's the right to act, essentially, right? So I have some questions about how far does that go, and are there some unintended consequences here? So, for example, polygamy is a practice that some religious faiths believe, and we can't challenge whether that belief is sincere or not. Let's assume that it is. Would this bill, if we adopt this bill, will that legalize polygamy?
Mr. Chafflin.
Chairman Singh, Representative Chestek, no. So that was a Supreme Court case, one of the first Supreme Court cases looking at the free exercise clause. And that was exactly the question, as you say, that was teed up to the courts. And there, that began a chain of a few cases. Early on, the government did not stop people from practicing their religions. It was only in the later 1800s and then more in the mid-1900s that you started having state action being such that it was stopping people from exercising their religion. So no is the short answer to that question. But to get at the question you were asking before that, what is religious practice and how does this work? Courts know is it a sincerely held religious belief? That's a first hurdle that needs to be passed. And then religious practice. So courts actually are not making a big distinction between are you religious in your beliefs and in your practice. Instead, the Supreme Court has been saying in their latest free exercise clause cases that religious status doesn't mean you don't get protected for your religious conduct. There are cases about the states not funding schools because they happen to not just be religious, but actually do things that are religious at their schools. And the Supreme Court said, no, you can't discriminate against them just because they act religiously as well. That was the latest from the Supreme Court on that. So religious practice is protected in that way. And what the test does, remember, it's when the government takes an action, when the state action is such that it would stop somebody from exercising their religion, that's when this would come into play. And then it's not the end of the story, because then there's a balancing test of whether the state has a compelling interest and takes the least restrictive means to pursue that compelling interest. And the studies show the states often win these cases. It's about 50-50, depending on how you draw the lines of how you categorize cases. But states can often meet that burden of proof in order to show that, yes, they need to stop, say, a criminal from doing criminal behavior. They don't hide behind a religious practice as a get-out-of-jail-free card.
Any follow-up? Representative Chestek?
Yeah, one final question along the same lines. The problem that I have with bills like this is that rights can be limited when they conflict with other rights. And my concern is that a bill like this might empower one right to the detriment of other rights. And here, the example I want to give you is current law is that same-sex marriage is legal, and people of the same gender, same sex, have the right, a constitutional right, to marry each other. So what happens when a same-sex couple applies for a marriage license, and the clerk at the court says, I believe that marriage is between one man and one woman, and therefore it offends my religious beliefs to issue a marriage license. I refuse to give you a marriage license, thereby depriving the same-sex couple of their right. Does this bill protect the clerk from being fired for not doing her job?
Mr. Chafflin?
Chairman Singh, Representative Chestek, this doesn't determine any particular outcome. At the very least, it at least gives that person a fair day in court to make their case as to why they shouldn't be forced to do something that might violate their conscience. And so that's why this test works. In the number of states, the 28 states that have this, and in federal law, we don't see that kind of parade of horribles happening frequently because, in fact, most people will give that license. Most people will not have a religious claim to it. And if they do, oftentimes I've seen just a handful of those cases where the clerk will say, oh, go to my colleague who's sitting right next to me. She'll take care of you. So there's no inconvenience there, and people can be accommodated, and that's why this test works. If somebody's religious faith can be accommodated by the state, it should be. And you're right, rights can conflict, and rights do have a limit. But religious freedom, remember, is a fundamental civil right. It's the first of our rights, and it deserves that high degree of protection, just like free speech and few others. But as a fundamental right, this is the test that the Supreme Court used to use, that the federal law uses, and 28 other states use. So that's why I would suggest that it's a good test to use to protect the fundamental civil right to religion here.
Representative Washit.
Mr. Chairman, I'd also like to add that, at least 2 of the states that have RFRA laws also have very active LGBTQ presence in those states. They're not seeing this law used to impugn them and limit them. And so this sets a standard for the test, but it doesn't decide the outcome of those types of cases.
Any other questions from the committee? All right, moving along, we got Mr. Winters.
Thank you, Mr. Chairman and committee. My name is Nathan Winters, president of the Wyoming Family Alliance, and it's a joy to be able to pick this issue up again because in the decade that has existed since I first introduced the law or the idea of this legislation, it's become abundantly clear that we need to have a Wyoming Religious Freedom Restoration Act. And this has been very well studied out, very carefully formulated. In this room today, we have 2 of the world's foremost experts on this subject, between Mr. Chaufin and behind us also is Mr. Lance Kinzer. And so when you consider what we're trying to do today, this is protecting, as the good representative just shared with you, a foundational right to free speech, protecting the First Amendment. The history of that in 2015, from a Wyoming perspective, it made it all the way through the House with flying colors. Sadly, what happened is the Senate never had a chance to even look at it. The then president took the bill along with 16 other bills, and it got caught up in a larger mix of issues, and so it was just pocket vetoed. It was placed in the drawer there, and people didn't have an opportunity on that side to actually hear the conversation. Because at the end of the day, this is a nonpartisan piece of legislation, and you can see that at the beginning in 1993 by how strongly it was passed. And in many other states, it's been passed in the same way, because it simply provides a reasonable adjudication to make sure that if an individual has something come against them that limits their rights, that this is a piece of law that can help prevent government coercion. It just gives a framework for a judge, for a court, to help form a decision along the lines of what was classically held strict scrutiny. So that's the reason I wanted to really bring this up. This should be nonpartisan because it simply empowers the person when the government begins to create laws that try to dominate over them. And so this has been very helpful across the nation and in the individual states that have passed it, 28 states, as well as there are versions in 9 states that have been kind of implemented through their state Supreme Court. And so this is a hole in Wyoming's law that needs to be filled, and you have the power to do that today. Thank you, Mr. Chairman. Stand for any questions.
Thank you, Mr. Winters. Any questions from the committee? Representative Lean.
Thank you, Chairman. Mr. Winters, thank you for being here today. The 9 states that have implemented it through the courts versus the 28 states, are those all inclusive under 28 total, or is that 9 plus 28?
Mr. Winters?
Thank you, Mr. Chairman, and Representative Lean. I believe they are in addition to those 28 that have passed it through the legislature.
Any other questions from the committee? I do have a question for Mr. Chaufin, and I'm sorry for butchering your name earlier. How would this bill interact with the Controlled Substance Act? And I'm aware that in the Native American church, they may use psychedelics in their practice. Can you tell me how this would interact with that?
Chairman Singh, yes, just as I was mentioning to your colleague, it works as case-by-case basis. If a Native American has a religious ceremony, say, so that Oregon versus Smith case that came up as the one that the Supreme Court changed the law with, they were actually counselors for alcohol abuse addiction, and they, in their Native American practice, used a controlled substance, which was illegal, and because of that, they were denied employment benefits after the case. Everyone was expecting them to win their case because there were other unemployment cases like theirs that they were victorious in, but that's when the law changed and they were less protective. Following that, Congress actually changed the law to accommodate religious practices for Native Americans like that. So the test would be used just like it would in any other situation where you have a religious practice being burdened by federal law. Now, if that's a federal law, federal RFRA already applies, and this wouldn't have anything to do with it. But if there's any state similarity, then it would just go through the same process it's already used at the federal level.
Any other questions from the committee? All right, let's move along to other comments. Let's start with any state agencies that would like to weigh in. And I'm not seeing anybody, so we can go ahead and move into public comment. And so let's start with folks that are in favor of this bill. If you're in favor of this bill, go ahead and come forward. Please state your name for the record.
Good morning, Mr. Chairman. My name is Steve Melia from Cheyenne, Wyoming. I stand in favor of this bill. We really need to have people be able to practice. During the COVID situation, there were several cases and reports that I had read about. One was that there was a pastor in Kentucky. He was holding a service in his parking lot. People were parked 8 feet apart in their cars with their windows rolled up, and the city said, no, you can't do that. And the police came, and he was arrested 25 times because he kept on holding them. And the police were taking down license plate numbers and issuing citations. And finally, they put nails all over the parking lot. So people would drive in there, they would get flat tires. And then there was a judge in San Diego. He said adult strip clubs are essential, churches are not. And there was another mega church that had a few people in there. They were all like, I think there's maybe 10 people in the entire place that could hold 500. They said, you can't do that. I think it was Governor Newsom said that you can hold some churches, but you cannot sing. And I'm going, they're really restricting a lot. So you could go to Walmart and you could park and you could go into Walmart and shop, but you couldn't go to church. I find that kind of ridiculous and discriminatory. So I stand in favor of this bill, and I thank you for the opportunity to comment.
Thank you, Mr. Melio. Any questions from the committee? All right, thank you. Any other folks that would like to testify in favor of this bill? Do we have any comment online? Okay, sir. All right, please state your name for the record.
There we go. My name is Lance Kinzer. I'm with First Amendment Partnership, a group out of Washington, D.C. that's the privilege of working with some of the largest religious faith groups in the country on issues of common concern around religious liberty. What I wanted to share today, and the reason I'm in Wyoming, was I served for 10 years in the Kansas House of Representatives, and 6 of those had the privilege of chairing our House Judiciary Committee. And I was also the sponsor of a RFRA bill in Kansas that passed in 2013. And I want to tell you the story of why we passed RFRA in Kansas. It's an unusual case, but it shows just how serious having strict scrutiny versus having rational basis can be. For one Kansas citizen, it was literally a matter of life and death. Mary Steinmetz, Jehovah's Witness, Medicaid recipient who needed an organ transplant. Her view around blood transfusions is not a view that I share. Candidly, it's a view that I don't even really understand. But it was important enough to her that she needed a very specific kind of procedure with respect to her organ transplant in order to fulfill her sincerely held religious beliefs. At the time, there was no Medicaid patient receiving hospital in Kansas that could perform the organ transplant in the way that she needed it. In order to go more than 50 miles outside of state lines to comply with Kansas Medicaid regulations, she had to receive a waiver from a board appointed by Governor Sebelius. That board would not allow her to go to Omaha, Nebraska, said that there was no rational basis for her request for that exemption to travel out of state. She litigated that case. She began through an administrative process, went through a district court process, and finally to the Kansas Court of Appeals. At every stage of that administrative and judicial process, the question was, does she get rational basis review on her pre-exercise claim, or does she get strict scrutiny? There are questions about the way that case was litigated, strategic decisions by attorneys, all sorts of things. But at the end of the day, the reality is that question was litigated for such a point of time that by the time she won her case before the Kansas Court of Appeals, her medical condition had deteriorated to a degree where she was no longer eligible for the transplant list. And in 2012, Mary Steinmetz, in the United States of America, in the middle of the country, died for her sincerely held religious belief around blood transfusions because there was not clarity on this question. This very case has actually been briefed multiple times in amicus briefs to the U.S. Supreme Court. Professor Laycock, who Greg mentioned, Mr. Chafin mentioned, has a great amicus brief that I'd be happy to share with any of the members that retells this story and makes the argument that it's a good reason why Employment Division v. Smith should be overturned. But what I'll say is this, and I'll just say a couple more really quick things. Mary Steinmetz died in 2013. We passed a RFRA, 2012. We passed a RFRA in Kansas in 2013. You don't want to wait until you have a case like Mary's to act. The reality is, and I've provided a map that you can see in the materials in that blue folder, this is a commonplace standard. It applies to every federal law, every federal civil rights law, every federal criminal law. It applies in 28 states, the same compelling state interest, least restrictive means standard. It applies in most of your neighboring states. And I will say, the gentleman who testified previously, 7 new states post-COVID have passed RFRAs because of the recognition that often it is state and local government action that most interferes with religious exercise. So we've had Montana, North Dakota, South Dakota, Nebraska, Iowa, West Virginia, all pass RFRAs in the aftermath of COVID. I think the core thing to remember, and it's, I think, been made clear, but I want to make it clear yet if I can, and then I'll be quiet. In all of these cases, the key is that RFRA, the standard, strict scrutiny, does not determine winners and losers by prejudging cases. Rather, it ensures that religious liberty claims are determined based upon a fair standard. So, for example, in the case that was mentioned, what about a clerk who has a religious exemption to same-sex marriage? What we know about those cases is that the state would have no problem saying we have a compelling interest in issuing lawful marriage licenses in our state. And if someone's religion is burdened, the question is just, are we using the least restrictive means? And if you're somewhere where there's only one person who has a non-delegable duty to issue marriage licenses, then the compelling state interest is clear, and the least restrictive means is to have the person who has the non-delegable duty do that. But the great thing about RFRA is that if there's a situation where the government can easily advance that compelling state interest by issuing the marriage license in the way that doesn't force one particular individual to violate their religious belief, then why not go ahead and do that? Why not provide accommodation? You know, Professor Laycock, and I will really close with this, Professor Laycock has been mentioned, who was in some ways I think one of the key authors of the federal RFRA, puts it this way: the best RFRA cases are the cases that never get brought. The best RFRA cases are the cases that, because this standard is in place, because local units of government or state agencies recognize, hey, what we're about to do may impact someone's religious belief or practice. If we do this, we're going to be held to a pretty high standard in court. Let's sit down and figure out with the affected party if there's a way that we can make this work for everybody. We can get done the core interests that the government's really looking to advance, but we can do it in a way that doesn't unduly burden this particular church, this particular individual. And so from my perspective, that's really the good news story. You don't see tons of state RFRA litigation in the states that pass RFRAs, but you see lots of anecdotal evidence about the way that it slightly switches the balance of power between government officials and individuals in a way that that produces results that can work well for everyone. So I'll stop my comments there and be pleased to answer any questions.
Thank you, Mr. Kinzer. Any questions on the committee? Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today. When you speak about a sincerely held religious belief, are you aware of any other states that are having those challenges aside from the Kansas case?
Well, there are many
Mr.
cases.
Kinzer?
Oh, I'm sorry. Yes, Mr. Chairman. There are many cases where issues of people's sincerely held religious beliefs being burdened by government action come up. So it's not as if, the sincerely held religious belief standard is kind of a gateway standard to the test. So you have to show that you have a sincerely held religious belief, and that's a real test. There actually are plenty of cases where someone attempts to use religion as a pretext, and courts are very good in those 28 states and at the federal level of recognizing pretext cases, and there's no reason to presume that the courts in Wyoming would be any less good about dealing with pretextual religious claims than federal courts and other state courts do. But yes, the Mary Steinmetz case was unique, and when I said it was unique because most of these cases aren't life and death, but it's not at all unique to have circumstances where governmental action, many times if we're talking about a minority religious group that may have a belief that seems esoteric to people in majority religions, it's a religious belief that maybe the government officials didn't even recognize they were violating in their action to begin with. So the general answer to your question, and in my materials I provided a long list of cases that show kind of pretty normal course fact scenarios where RFRA comes into play. So yeah, it's by no means unique to that one case in Kansas, that's for sure.
Representative Lean, any follow-up? Any other questions from the committee? I'd just like to add that it's remarkable that for a religion, the Jehovah's Witnesses, they were founded in the United States of America. They were only able to express their religious beliefs because they lived in this country where you have freedom of religion. And though I don't necessarily agree with their tenets, it is special that we live in a country where they're able to exercise their free belief of religion. So, all right, moving along. If there are no other questions for Mr. Kinzer, let's go ahead and move to a public comment in opposition to the bill. Any folks in opposition to the bill today? Come on up. Please state your name for the record. Welcome.
Thank you, Mr. Chairman. Thank you, committee. My name is Sarah Burlingame. I'm the Executive Director of Wyoming Equality, and we are in qualified opposition to this bill. And I just wanted to give you guys a little bit of history of Wyoming Equality and how we've approached RFRA and how statewide LGBTQ advocacy orgs have seen these Religious Freedom Restoration Acts. Traditionally, we saw them as people seeking the ability to actively discriminate against the LGBTQ community, again, using the color of law. And the thing that's changed in the last decade is that statewide orgs, particularly from red states like Wyoming, but also others, have joined with religious organizations in a sincere effort to understand each other's unique needs. So here in Wyoming, there was an effort to pass a non-discrimination bill. Most recently in 2015 is when we got sort of, the most momentum behind it. And Wyoming was unique in that we had something called, we called it the Perkins Amendment, but it was allowing for expressive association and non-discrimination. And for folks who aren't familiar with expressive association, sometimes we call it the Boy Scout rule, saying Boy Scouts aren't a church, right? And so you may not see them in that First Amendment protection, but they have an expressive affiliation with faith. And so we considered it not just strategically but sincerely, as they have a missional purpose, they're working to advance a religious perspective, and so they should be captured in that non-discrimination. And we think that that earned us some goodwill because people saw that we weren't attempting to just say, hey, if you have a religious faith, we think that our rights should supersede yours. But rather, we live in a pluralistic society. We all have to live together. How can I make sure that your rights are protected and acknowledged, but I want them done right alongside mine as well? And I want to make sure that yours aren't used to actively discriminate against me and my community. I think that, Elder Oaks, who is sort of the author of what I'm going to suggest, is twinning, always marrying the idea of non-discrimination for LGBTQ people with religious liberty. So if you're not familiar with the Utah Compromise, which passed in 2015, it was landmark legislation because it said, it didn't include accommodation, but it had housing and hiring, kind of the big two. And it said, you shall not discriminate based on someone's gender identity or sexual orientation. But it also put alongside it really robust religious freedom rights. And it put it in the exact same legislation. And so you had the leaders of the Church of Jesus Christ of Latter-day Saints in open support of this. And you had the leader of Utah Equality coming out in full support of it. And so our suggestion, as some of the folks have mentioned, there are 28 states that have passed this, and Representative Lean is correct. There are 9 states in addition who have done it through the courts. That's a lot of RFRA out there. And I don't have the exact number, but because I don't want to misstate it, because I'm not sure how they map exactly onto that. But I think the majority of them also have some kind of non-discrimination, which Wyoming lacks. And so if we wanted to meet each other in good faith and say, that's absolutely right, like Representative Singh is right, like what other country but the United States of America has given the robustness to religious liberty that we have? But we also make sure that everyone is protected, and we don't use our First Amendment rights as a bludgeon. We use it as a protection. And so I would suggest an amendment that said that nothing in this bill shall be used to discriminate on the basis of gender identity or sexual orientation. And I would stand for any questions.
Committee, any questions for Ms. Burlingame? Seeing none, thank you. All righty, do we have any other folks that would like to testify against this bill? Anything online? All right, going once. Representative Washington.
Thank you, Mr. Chairman. I'll bring us home. I don't think that amendment would be necessary in Wyoming because all we're changing here is the standard by which the judicial branch will evaluate these cases. You still have to prove your case. And that doesn't change. When we look at RFRA laws across the country, we have robust diversity of opinion in many of the states that have RFRA laws. The existence of a RFRA law does not compromise that, and it wouldn't do it here either. It just guarantees that every party who believes that they've been burdened by a government action will have a fair day in court to litigate their position on their merits of their religious freedom claim. That's what this bill does. And so we can get off in the weeds and start talking about all sorts of hypothetical, maybe, coulda, woulda type situations. But in its essence, this bill simply changes a legal standard. That's all it does. And then the cases will rise and fall on their own merits. Thank you.
Thank you, Representative Washington. Any other questions from the committee? If not, going once, twice, 3 times. All right, we'll go ahead and close public comment. Committee, what's your pleasure?
Second?
Moved by Representative Kelly, seconded by Representative Lee. Any discussion on the bill? Any amendments? Representative Chestic?
I don't have any amendments at this time, although I do want to speak with one of the witnesses later on about a potential amendment later on. I just want to discuss the bill briefly. I want to explain, I will be voting against the bill, but I want to explain that I'm not voting against it because I am in any way anti-religion. That is, I go to church every Sunday. I delivered the sermon in church 2 weeks ago, a week ago, in my church. I believe in religious freedom. I am absolutely committed to the First Amendment freedom of religion. But the First Amendment has two religion clauses in it, free exercise clause and the establishment clause. And to some extent, they're in tension with each other. They can, in times, come in conflict with each other. I think both clauses can be reconciled with each other very easily by understanding them as defensive, as shields, not as swords, but as shields. So the free exercise clause says that the individual's right to believe what they want to believe is absolute. And you can defend, you can't be forced to believe something you don't want to believe. That's absolute. The establishment clause prevents protects an individual from the government telling them what to believe or other people telling them what to believe. So I think the two clauses are reconcilable. Where the problem comes is when one of the clauses, and it's the free exercise clause that is used in this way sometimes by some people, is to use it as a sword to say, my religious belief trumps your belief. And I'm right, and therefore your rights, since I don't believe in your rights, I don't have to honor your rights. And the example I gave in my questions are some of the examples of how that works. So yes, this bill does change a standard, but it changes a standard in favor of using the free exercise clause as a sword, as a thumb on the scale, in favor of those who would use the free exercise clause as a sword to say, my religious belief trumps your religious belief. I don't like that. I think that is, that violates the separation of church and state to some extent. I absolutely believe in the separation of church and state. I think both church and state benefit from that separation. Both do. So for that reason, because this bill, I believe, does put a thumb on the scale in favor of individuals who would, I think, misuse the free exercise clause and turn it into a sword against other people's rights, I therefore have to oppose this bill. Thank you.
Thank you for your insights, Representative Chestic. Any other comment on the bill? Let's just walk through it. Any amendments on page 1? Page 2? Page 3? Page 4? Page 5? Or page 6? All right, seeing no amendments. Chief Clerk, please call the roll.
Representative Brady?
Aye.
Representative Breton?
Aye.
Representative Chestek?
No.
Representative Filer?
He's left an absentee vote of aye.
Representative Kelly?
Aye.
Representative Lean?
Aye.
Vice Chair Singh?
Aye.
Representative Webb?
Aye.
Chairman Washut?
Aye.
8 ayes, 1 no.
Thank you. With that, the reins are yours, Chairman Washut.
Thank you, committee. That brings us to House Bill 54. Thank you to all of you who testified in the previous bill. Now we bring up House Bill 54, Chancery Court Judges, District and Circuit Court Assistants. Ms. Butler, welcome this morning. I'll introduce the bill and then you can chime in a little bit if you would. So committee, House Bill 54 is another bill coming out of the Joint Judiciary Committee over the interim. The history of this was a few years back, the Wyoming legislature created a chancery court. A chancery court is a business court where litigants can resolve typically contractual disputes between business entities in a more expedited fashion. The Chancery Court does not do jury trials. They do them all before the judge on the bench. They typically have a very expedited docket so that the cases come up and are resolved quickly, which is advantageous to business. The purpose of the Chancery Court was to make Wyoming a more hospitable place for corporations to reside, to be incorporated in our state, under our state laws. And it's the way it's worked out. So just a couple months ago, I think it was in December, Wyoming swore in its first Chancery Court judge, a full-time judge. It's the equivalent position of a district court judge, but assigned specifically to Chancery Court. The number of cases that are coming up before the Chancery Court has gradually been increasing. But the way these develop is that as new contracts are written, the parties to the contract will designate the Chancery Court as the venue for resolving disputes over the contract. So longstanding contracts that existed before the Chancery Court was established don't have those clauses. So the Chancery Court is not the venue for reconciliation of those disputes. Newer contracts are including Chancery Court more often, so the caseload is growing. But at present, the workload for the Chancery Court judge goes up and it goes down. And I believe Ms. Butler is going to testify to that. And so what this bill does is allow the Chancery Court judge, rather than sitting idle in between Chancery Court cases, to backfill, if you will, circuit court and district courts that might need the help of an additional judge. So this bill would authorize the Chancery Court judge to fill in for a district or circuit court judge who might be out ill, or a circuit court or district court judge who might just be overwhelmed with workload at a particular point in time. So it helps us, I think, on an efficiency standpoint, get our money's worth out of this Chancery Court judge. That's the basis of the bill. And Ms. Butler, if you want to chime in and elucidate further.
Mr. Chairman, thank you. Members of the committee, my name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. The only other thing that I would add is these statutory changes, this bill provides some consistency across court jurisdictions. So right now, what we have statutorily is the statutes authorize, for instance, a circuit court judge to take on a district court case in certain circumstances. And so the same for district court. A district court judge can take on a circuit court case in certain circumstances. And so this provides some consistency across all of our trial court jurisdictions, where judges from each of those jurisdictions, circuit, district, and chancery, can all contribute when necessary in another jurisdiction. And again, there are some circumstances that each of those judges would have to meet if they're going, for instance, from circuit to district. But it does allow for that in scenarios, as the chairman discussed, which could include an illness, a long-time illness, a death in the family, a conflict case. Sometimes our judges are conflicted out of certain cases ethically. So it allows for our judges to be utilized statewide in a more efficient manner. And with that, Mr. Chairman, I'd be happy to answer any questions that the committee may have.
Ms. Butler, Representative Bratton brought this to my attention before the meeting today, that on page 3 of the bill, 53112, titled Assignment to Circuit Court Judge, and then 59131, assignment to district court judge or chancery court judge. Is there a need to add the or chancery court judge language to the title of 53112? Ms. Butler?
Mr. Chairman, and thank you to you and Representative Bratton. That was something that I had noticed this morning myself and should have brought to your attention, but I agree absolutely that the title on 53112 should include a chancery court judge.
Thank you. Further questions for Ms. Butler? Mr. Vice Chairman.
Thank you, Mr. Chairman. Ms. Butler, can you just elaborate on why these particular types of cases would not qualify for a jury trial?
Ms. Butler.
Mr. Chairman, Representative Singh, that was the intent of the legislature when the legislation was passed that created the Chancery Court. And so the idea behind the Chancery Court really is to substantially expedite the time that it takes to resolve cases that come before the Chancery Court. And when you have a jury trial, that slows things down pretty substantially. And so trial to a court rather than trial to a jury was the choice in this limited jurisdiction case, so they don't get to hear every kind of case similar to like a district court would. But the idea is to really expedite the time frame between when you file and when you get a resolution of your case. And so that's why the choice was made to have a trial to the bench rather than to a jury. And one of the things that I would say, Mr. Vice Chair, is that the district courts and the Chancery Court have concurrent jurisdiction. And so what that means is that those cases that are heard in Chancery Court can also be heard in district court. And so if a litigant decides, I really need a quick resolution of this case, so I'm going to choose Chancery Court, but that means what I'm going to be giving up is a jury trial. I know I'm going to get a trial to the judge. Or they could decide, I really need a jury trial in this instance. And so I'm going to choose to go ahead and file into district court. That means the resolution to my case will likely be slower, but it means that I will have the opportunity to try that case to a jury if we get that far in the case. I hope that makes sense, but I'm happy to answer any other questions.
Vice Chair, follow-up? Other question? Representative Webb.
Thank you, Mr. Chairman. My question is there any difference in qualifications for a Chancery Court judge versus a Circuit Court judge versus a District Court judge?
Ms. Butler.
Mr. Chairman, Representative Webb, the answer is generally no. So there are limited qualifications for any kind of judge or justice within the state. I can't tell you what those are off the top of my head, but things such as you have to reside in the district where you're going to preside. You have to be of a certain age. So those are the minimum qualifications. Generally, when judges are going through the selection process, that's when they are going to highlight their experience that maybe qualifies them for a circuit court judgeship as opposed to a district court judgeship as opposed to a Chancery Court judgeship. So when they're actually applying is going to be when the Judicial Nominating Commission and the governor are really going to look at those other qualifications, like how much experience they have in business litigation, right? Where they are making that selection as opposed to like a statutory or constitutional qualification. I hope that makes sense, but I'm happy to clarify if it does not.
No, I think I see where you're going, so thank you.
Representative Lean.
Thank you, Chairman. My question is about the travel expenses and a day wage. So on page 4 of this piece of legislation, it kind of outlines a little bit about the expenses of the judge. Is the district court also responsible for a day wage when the judge is already collecting a salary? Or are they only there to collect a per diem and any extra cost incurred by the courts?
Ms. Butler.
Mr. Chairman, Representative Lean, so if you have the Chancery Court sitting in for a district court judge, they receive statutorily a certain salary, right? So they're not going to get additional money for going to, say, Jackson to cover in terms of a salary, but what they will receive is things like per diem to stay there, and that will come out of that court's budget. So if they're covering for the Jackson District Court, the per diem to cover the cost of travel and overnight stays and those kinds of things will come out of that court's budget, but they don't get additional salary dollars for covering for another judge.
Follow-up.
Thank you, Mr. Chairman. Changing topics a little bit, I understand that the Chancery Court is a robust business law court, and I'm wondering if by allowing them to oversee some of the civil litigation within a district court, does that inhibit their ability to then come back and oversee a robust business law court as a Chancery judge?
Ms. Beller.
Mr. Chairman, Representative Lean, so I believe just a kind of an explanation about the process and how this would work. Generally, when you're going to have for instance, a district court judge that has, say, a conflict case, so they can't preside over that case because there's some ethical conflict. What that district court judge may do is they may reach out to the Chancery Court judge and say, I have this ethical conflict, can you take this case for me? And if that Chancery Court judge has no room at that point to take that case, if there's a trial coming up, if they're working on 16 different orders, it's unlikely that the Chancery Court is going to say, yes, I'm happy to take that case. Because the Chancery Court statutorily and by rule has some very strict timelines that it has to meet because we are looking for fast resolution. So it would be a docket management decision for each of the judges to really determine whether or not they have this space in their current docket to cover a case. So I would say generally no, Representative Lean, just because the decision on whether to take a case will be up to the judge. There is no requirement that they do so.
Thank you, Chairman. One more topic shift here. When there is a vacancy and we do need to fill that within time, I remember reading that our Chief Justice has the ability to appoint in a timely manner somebody to fill that vacancy, but I can't remember where to find it. Do you by chance know where that is?
Ms. Butler.
Mr. Chairman, Representative Lean, I can't tell you so constitutionally, when we have a vacancy, and I cannot cite to the specific constitutional provision, but constitutionally, when there's a judicial vacancy, it has to go through the nomination process, the judicial nomination process, selection process in order to fill that vacancy. If there was an emergency situation, say there was a death of a judge, what we would do as a branch is we would fill in with other judges to manage that docket until that constitutional process could go forth. And so that constitutional process obviously requires a couple of different steps, takes a little while, it takes about 4 months, I believe, to fill a vacancy. And so what will happen is when there's a vacancy, people will apply who are qualified. The Judicial Nominating Commission meets and determines who they will interview. Then the commission goes to the location where the vacancy exists and they will interview those applicants. And then 3 of those names go to the governor. The governor then does, and then the selection or the appointment comes from the governor, him or herself, maybe in the future. So that's the process. And so to fill a vacancy full-time, that's what it would require constitutionally. If we had a vacancy that we had to fill short-time, we would use other judges to fill in.
Thank you. So 51106 is the statutory provision that gives the appointment authority to the Chief Justice in those unanticipated vacancies. Yeah. Representative Brady.
Thank you, Chairman. I do have a question. How many, since this is quite a new court relatively, and how many judges right now are on the Chancery Court?
Ms. Butler.
Mr. Chairman, Representative Brady, so we have 1 full-time Chancery Court judge who covers all of the Chancery Court cases. That judge was sworn in, I believe, January 2nd of this year, so brand new judge. Prior to that, we had 2 district court judges who stepped in and did the work of the Chancery Court.
Okay, thank you.
Further questions? Representative Bratton.
Thank you, Mr. Chairman. I have just a clarifying question, and it doesn't apply to the Chancery Court, but it has to do with the impact the bill would have on the district courts assigning cases to the civil court. On page 3, lines 12 to 14, so today for a district court to assign a case, both litigants have to consent in a civil case more than $50,000. So the current requirement is being changed so that all the assignments from district court to civil court require both litigants to consent regardless of the size of the case. So my actual question is, why is the $50,000 requirement in there now? I kind of know why that is, but I just want you to comment on that. And what would be the impact of removing that requirement today for a district court to assign that?
Ms. Butler.
Mr. Chairman, Representative Bratton, so the reason that that exists today as the statute currently stands is because that statute only applies to circuit courts. So what it says is you can assign a circuit court judge to a district court case in certain circumstances. And because the jurisdiction of the circuit court is circuit court judges can hear anything under $50,000. They're a limited jurisdiction court. They cannot hear anything over $50,000. And so if the circuit court judge is assigned to a district court case, they would need consent of the parties. Essentially, I don't think this changes the statute at all, except for it allows for a chancery court judge to step in. Chancery court judges, as I said, have concurrent jurisdiction with district courts. And so what that means is the chancery court judge can hear anything over $50,000 in those kinds of cases, I believe. And so this just removes that dollar amount. Essentially, it still remains that the parties have to agree regardless of the jurisdictional amount.
Thank you.
Further questions? Seeing none, thank you, Ms. Butler. Appreciate you being here today.
Thank you.
Anyone else in the room wishing to testify on House Bill 54? House Bill 54. Anybody on Zoom? Going to close public comment. Committee, what's your pleasure? Moved by Vice Chairman, second by Representative Webb. Discussion on the bill or amendments on the bill? Representative Bratton.
I would just like to amend on page 3, line 4, the title, just assignment to circuit court judge, be changed to insert or chancery court judge, just to make the two that consistent with line 16, 59131.
Motion by Representative Bratton, second by Representative Chestic. Pierre, do you have that? Everybody clear? Any discussion on the amendment? All in favor of the amendment, say aye.
Aye.
Those opposed, no. The amendment carries. Any further amendments? Any discussion on the bill? Seeing none, Pierre, we want to call the, Representative Lee.
Sorry, I didn't mean to cut you off, Chairman. Chairman, I just wonder, in the testimony we heard today, we hear that these vacancies are already being filled. And so I'm wondering if it's a necessity or if the judge already has the ability to move about. Are we just putting this in the green books for clarity? Or do we really need this to make sure that the judges know that they can move about to fill in vacancies or over workload within the system?
My understanding that without this statute, the Chancery Court judge could not be appointed to any of these vacancies on a temporary basis, that this statutory change is necessary in order to accommodate that. So presently, we move retired judges sometimes, or we use circuit court judges from less busy districts to cover in busier circuits, and district court judges from, moving around. This just adds the flexibility of using the Chancery Court judge as well, if time allows. But without it, the Chancery Court judge would sit idle perhaps at times between cases. With that, Pierre, we're going to call the roll.
Representative Brady,
Aye.
Representative Bratton,
Aye.
Representative Chestek,
Aye.
Representative Filer,
He left an absentee vote of aye.
Representative Kelly,
Aye.
Representative Lean,
No?
Vice Chair Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
8 ayes, 1 no.
Thank you. Do we have a volunteer to carry the bill on the floor? Anybody want to carry this one? I guess I'll take it. All right, all right. And that concludes our business for today. Thank you all for attending. Bye now.